I'm sheltering in place, which seems to be the order of the day. Just a little bit about me. I've been an investigator my entire life. I started when I was 17 years old, and I'm now almost 65, so I've been doing it for a long time. I primarily and exclusively do workplace investigations for businesses throughout California and the United States. And those are any type of investigation that's in the workplace. I've also been involved very actively with several associations in the country and have been the president of a California association. As far as golf courses, I was a member of a private club up in Sonoma County for many, many years and was on the board of directors and ultimately the president. So I've had personal hands-on experience dealing with problems in the workplace at a country club. And as Mike pointed out, I think primarily our biggest problem had to do with members doing things towards employees that were completely inappropriate, out of line, harassing, bullying, things like that. It just seemed to be a chronic issue at the club. Today, we're going to just talk about various types of complaints and what those look like. Some of these are the types of complaints that you'll hopefully never see, but obviously sexual harassment, a hostile work environment, whistleblower complaints, manager-employee types of complaints, and also embezzlement and theft. I've done several cases involving clubs where when they don't have a closed till, they figure out a way to steal money, and we've had to go in and set up various different types of operations, either to watch the till or set up video operations to catch people stealing money, unfortunately. So the most important thing and that you need to know is that there's always a duty to investigate. No matter how big or small, you have a duty to investigate. And so what you're going to see today is the process that I go through with every investigation in a workplace. And it may appear to you to be very daunting, and you may say, I could never do that, it's just too much work. You can scale this down and keep it really as simple as it needs to be. You just have to follow some of the very basic steps to document what you're doing, how you're doing it, and the approach that you take. If you take the same approach every time, your investigation will be, airtight. There's never an expectation that you're always going to get it right. You can do an investigation, reach a conclusion, and you may be wrong. It could turn out later, 6 months later, that you made the wrong call. But if you follow the right steps, then you're still protecting the club, protecting the management from external lawsuits. In other words, you can get sued, go through the process, but if you've done an appropriate investigation, as we're going to talk about today, it covers you. It just has to be adequate, and it's got to be very thorough. Initially, these were a couple of cases. The Cotran case and Fuller versus City of Oakland are two leading cases that talk about obviously that you have to investigate, and it has to be adequate. And if there's a failure to promptly interview and conduct an investigation, then you're exposing yourself to problems. And if not, you don't want to be accused of having a biased investigation. It's just not going to work. And this is probably the last slide regarding a court case. I don't like to talk about court cases, but Mendoza versus Western was basically a case of all the things that you should not do when you're going to be handling a workplace investigation. In this case, they had no investigation plan, which means they didn't sit down at their desk and say, okay, we're going to do A, B, C, and D. They did not use a trained investigator. They just had somebody on staff start asking questions. And the primary mistake they made was they put the complainant and they put the respondent in the same room together and asked them to tell them what happened, which is really a convenient way to try to get something solved very quickly. But in workplace investigations, it is the absolute worst thing that you can do. And it will open you up to so many other problems of retaliation, intimidation, and it makes both employees extremely uncomfortable. you can imagine what it would be like having a member in the room with an employee trying to hash out a problem. It would not be a good thing. And members do have egos, and they get offended every time you try to question something that they do. And if you bring the employee in who's made an allegation, you can imagine how that's going to go. The last thing that they did not do is they did not do a credibility assessment or a character assessment, which is, again, something that we'll talk about. And it's very, very important because almost all these types of cases are he said, she said cases. They happen privately when nobody's looking. And you say, well, how am I going to sort that out? And it's very important that you learn how to develop the skills of assessing someone's credibility. And that can be very simple. Whoops, sorry, my phone's gone crazy. And that's going to require, obviously, their ability to recall their bias and motive for lying and various things that you can do independently to determine if you think that person is credible. And again, if you go through the steps to do that, even if you're wrong, as long as you're in good faith following the steps, your investigation will be protected. And that's really what you have to think about. Now, the audience I understand I'm talking to are all HR people, general managers, people who may be in a position where they might one day have to do one of these types of investigations. The most important thing that I do and why I'm called in to investigate is because I am an objective third party. I don't have a stake in the game. So I can come in, and regardless of who's who, I get to call it like I see it because that's my job. You may be called upon to impose discipline or develop remedial plans. If you do that, obviously you need to make sure that there are other people participating or that you're sharing your decision with. And that may make it difficult for you to be objective if in fact you're going to be the decider for discipline. It's always a good practice to try and have somebody else do the investigation if you're going to be the one that's going to sit down and say, okay, we're going to suspend you or fire you, or we're going to suspend you from the club when you're dealing with a member. You just need to try and do everything you can to reduce your bias, no matter how you may feel about the people you're investigating. It's always important to set aside those biases when you walk through the front door. If any of you get into a position where you have to investigate upper management or somebody above you, it's extremely dangerous. I would not recommend it. Sometimes members of the board do things that are out of line and inappropriate, and they'll ask a HR person to conduct the investigation. I would run as fast as I could from that, because you don't want to be that person who has to be in the club while that board member knows you're doing the investigation, especially if it doesn't go the way that board member wants it to go. It's a very difficult place to be, and the club's setting itself up for the person that did the investigation to then claim they're being retaliated against if it happens to be that you make a call against somebody on your board or even against a member. Investigation of a peer, general manager investigating the HR director, your food and beverage person. I mean, the general manager can do that. You wouldn't want your HR person probably conducting an investigation of the food and beverage person, because they're kind of on the same plane. Again, it's very difficult to do. So picking the right person to handle the investigation. I'm an old white guy, and there's going to be times when, certainly in this business, there are all kinds of minorities, ethnicities, and it can be very, very complex. And no matter what you think or how you want to go about your investigation, the important thing is just getting the right person. It doesn't mean they have to be, if it's someone who's African American, you get an African American investigator, or if it's a harassment case involving a woman, you get a woman investigator. You really need to just get somebody who has experience, and someone who will, because someone's always going to object to the investigator. And that's a common thing. They'll say, you can't be fair because you're an old white guy like me. And that really isn't a good justification. And you just have to set that aside when you get those objections. There's nothing you can do about it. I always say just pick the most qualified person to do the investigation. If you follow the right steps, you overcome the bias anyway. So when I start my investigations, and this is again what I do every time, and I will suggest to you that you also do this. A complaint comes into the office and you're looking into it. The first thing you want to do is identify what the scope of the investigation is. What are the people saying? And you also want to find out what remedy they want. What are they asking you to do? I then always refer to the company policies and procedures so that I can make sure I know that there is in fact a policy. One of the big things going on right now in the harassment world is what we call bullying. And a lot of clubs don't have a bullying policy, and it doesn't, it impacts everybody. And you can't just say it's based on your gender, ethnicity. Bullying is bullying. And you don't have to be in a protected class to get bullied. And I encourage all clubs to develop a bullying policy so that you have it in place, because it is kind of where everybody's going. If you're not in a protected class, you can't say, well, I'm gay and they did this thing to me. Even if you're not, they'll claim that they got bullied, and you should have a policy for that. I know a lot of clubs have union contracts, and I always look at the collective bargaining agreement or the union contract to make sure that what I'm investigating is appropriate under the union contract and that we're following it step by step. I typically don't get into grievances. Grievances really are whether or not someone's violating the contract, and it's not my personal practice to involve myself in a grievance. People think that these investigations are a grievance process. I always make sure that they understand that it's not. The next step obviously is interviews and evidence gathering. And that will require, looking for all the various pieces of evidence that are out there that might help me gather and get to the truth. Again, even on the smallest level, you still want to have a plan that goes through all of these items. You also want to make sure there's an expectation regarding the report that you're going to write. If you talk to a complainant always wants to get a copy of the report, and I always have to say, you're not going to get a copy of the report, that you're really not entitled to it. And in this business, we say that because everybody has a right to privacy, no matter who they are. And if you interview 10 or 5 or 100 people, everybody wants to maintain confidentiality as much as they can. And you have to respect that. So when I talk to the complainant, I always say the most frustrating part of this process is that you're not going to see the report. You're not going to find out what Johnny said happened. The only thing that you give anybody is a finding, and that's going to be, there's an allegation that so-and-so did ABC, and the finding is that it was sustained or not sustained, and a brief summary as to why you reached that conclusion. And it's very important that you maintain that kind of that distance from the report, because the report can have a lot of stuff in it that can get a lot of people upset and angry. And you just don't want to do that, especially when it involves members talking about other members. Can you imagine if the person gets the report, what they're going to do is they're going to bring it to the bar and go through it with their friends. As inappropriate as that may sound, they will do it. And so you just can't be in that position. You have to maintain that confidentiality and tell people up front. You develop the most anger when a complainant really doesn't have a sense of what's supposed to happen. So the more you can give them a roadmap, say we're going to go through here, 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 here. At the end, I'm going to write you a finding, and that's going to be it. Again, if the contract involving a union person allows them to appeal a finding, then obviously that process has to be made available to them. As far as discipline and recommendations, again, the complainant never gets to know what that is. I never tell somebody. I stay out of the discipline business if I can. There are occasions when I'll be asked to make a recommendation, And I try not to. It's just my role is a fact finder. And again, if you're the HR person, unless that is going to be your role all the way through, best to let the general manager do that with you, or have it passed off to somebody. Sometimes the board of directors wants to be the end all, where they're going to write the letter to a member or to somebody about what the discipline is. But it can really complicate an investigation if you start doing both things. So as we talked about, again, the keys to a proper investigation: a lack of bias. You'd have to be fair to everyone. You have to apply the rules equitably, which means if you're going to start a process of how an interview is going to be conducted, you need to do it for everybody. If you're going to allow a witness to be present as a support person for the complainant, and the respondent comes in with a support person, you can't say, well, sorry, you don't get to have somebody. Again, then that person thinks you're biased. They may already know that the complainant had a support person there. And so you don't want to have yourself in a position where they're saying you're biased just because you made that choice. Your findings have to be supported by evidence. You may hear from the complainant about what a member did, and you've got a gut feeling because you've been around the member and you've seen their conduct that you know it's true. You just have to set that aside. You can't have a predetermined outcome, or you're back to where we were with those cases we talked about in the beginning, which is that it's a flawed investigation. So if you think you're in a position where you can't be objective, you need to find somebody else to do it, or you hire someone like me. So in all the court cases, they talk about what we call a sham investigation, which means you have a predetermined result, which means the general manager comes to you and says, we really got to get rid of this person. And you're like, now what do I do? Not a good place to be. Ignoring witnesses. You can't ignore relevant witnesses. That doesn't mean you have to talk to every witness, but you have to make a good faith attempt to speak to enough people so that you have given a fair opportunity to get both sides of the story. You can't just talk to the complainant's witnesses or just the respondent's witnesses. Even if you know they probably have nothing to say, sometimes it's a good idea just to go in and talk to more than just the two people. You've got to get more of that story. Also, you don't want to let the employee direct the investigator. You need to always maintain your independence. Once you start your investigation, no matter who you are, if you're the general manager, HR, board members asking questions, you just got to tell them it's confidential. I really can't share this with you. Again, you have to maintain your objectivity. If the GM comes and wants to put pressure on you to get it done faster, you say, we're going as fast as we can. You really have to learn how to say no. You get examples of conduct that I investigate: members harassing staff. I can't tell you how many times a member grabbed a female waitress and thought putting her on his lap was a great thing to do when there's only 4 people in the bar at 10 o'clock at night, or they're in the middle of a card game, and they decide to go take a shower while the waitress comes in, and then they come strolling out in their towel, and then they make some crack to her or him that's inappropriate. Bullying, again, is a very big thing. We do get some meals and breaks complaints, but again, those are usually tied into contracts. So we don't do a lot of those. Same with overtime, where managers are requiring people to work overtime. They threaten them, say, we'll fire you, we'll do this, we'll do that. And sometimes those are contract issues, but in some clubs, they're not. Board misconduct is, again, something that's very prevalent because board members believe they're empowered to do things and order people around when they really don't have that authority. And then there's theft. There's food out the back door, alcohol out the back door, gas, gasoline, registers, theft from your range machines if you have them, which some clubs still use those. A lot of clubs don't. So those are the kinds of things that I do when I'm doing country club investigations, and the kinds of things that you obviously will be seeing every day. So confidentiality, what can you promise? Essentially, you can't promise confidentiality because ultimately there's a chance that the report could become public. There could be a lawsuit. There could be an arbitration proceeding. You are allowed to tell people that you can maintain their confidentiality up to a certain point. And what that means is you can, and I do, complete an investigation and someone says, I don't want my name used. And you can tell them, well, your name will be kept confidential up until the point where if there's an administrative hearing, an arbitration, collective bargaining will sometimes allow that to happen, or a lawsuit, then that person's name has to be disclosed. The complainant has an absolute right to know who was giving evidence against them when you get to the point where you've made a finding and now you're going to take discipline and they want to go to that next step, either an administrative hearing, arbitration, or a lawsuit. That's going to happen. In the cases that I handle, I typically will not allow myself to be retained directly by a club because that takes away all the attorney-client protections and the attorney work product protections, which means that if I'm hired by the attorney, my report goes to the attorney and not to the club. All the information I've gathered is gathered at the behest of the attorney, and nobody can see that unless they file a lawsuit. And at that point, some of the information can be available. So I always recommend that if you're going to go down that road where you're going to hire an investigator, that you still run it through your attorney. It may cost a little more in the front end, but on the back end, you're going to save a lot of time and money. My findings then go to the attorney, and then the attorney turns around and works with the board of the GM to determine what to do next in terms of discipline, anything like that. You also need to make sure with confidentiality that there's a protection from retaliation, which is another reason why you don't want to tell people who you're talking to. You know, if someone says, well, have you talked to Bill, John, or Susie? You don't say yes or no, because you don't know what the motive is and you don't know the relationships. It's very, very important that you don't tell people who you're talking to, which means when you structure your interviews, don't have 5 people waiting out in the lobby. Bring them in as best you can in a discreet manner, even if you have to go somewhere else where you know other employees won't be seeing those employees, or do it away from work if you have to. Or what do you tell coworkers? The answer is always nothing. Again, you just have to maintain a certain degree of confidentiality or it just messes up the whole thing. And so these are very simple things that, again, I follow and you should follow. These are best practices for you to maintain the integrity of an investigation. In my business, I'm always thinking what the end looks like, not what the beginning looks like. And the end can be a lawsuit, it can be an administrative hearing, and knowing what those look like, if you've never been to one, they're not fun, and everything you do gets questioned because somebody's trying to poke holes in what you've done. So always think about what it's going to look like at the end, and do you want to be on a witness stand answering a question about something that you did that was borderline unethical or inappropriate. So again, what's your duty? You must investigate an allegation of wrongdoing. You can't ignore it, no matter who it is. If you do, you're opening yourself up to significant liability. You just have to investigate everything. A proper investigation has to be prompt and thorough. And again, the conclusions have to be reasoned. They can't just be, oh, I had a gut feeling after that interview. And again, don't do what you think your boss wants you to do. As I mentioned earlier, you may be wrong. That's okay, as long as you follow the process. Government interview witnesses or people that have union contracts, it's a little different in terms of compelling somebody to testify or to give a statement. When you're doing an employee theft matter and there's a union contract, you can make them give a statement, even though they say they have a Fifth Amendment right. There are a couple of cases that allow for the employer to question the person. The guarantee has to be that the statement's never going to be turned over to law enforcement unless there's a subpoena or a search warrant. And it can't be used in a criminal case because it's considered a coerced statement. In other words, you're telling somebody, if you don't talk to me, I'm going to fire you or discipline you. And that makes the statement coerced. And for that reason, the employee has to talk to you or face discipline. Now, if it's a serious case and they know they're guilty, some people would rather take the insubordination rather than something else, like admitting to their wrongdoing. And so a lot of cases we'll find that the witness says, I'm not going to talk to you, I'm getting fired anyway. But make sure you know what their rights are, especially if there's a union contract in place. So again, these are the things, hunting and gathering is what I call it, things that I do. I take witness statements. I always start with the complainant, and I always finish with the respondent, and then I do my follow-up interviews. And in between are going to be all the witnesses for both sides. There's almost always follow-up once the respondent tells their story. Some of the best evidence can be electronic communications, which are text messages, email, you name it, Pinterest. People communicate in all kinds of different ways these days, and you can ask for that. And if you have a technology policy in place where you're giving some of your managers phones to use, you have a right to take that phone and look at everything that's in it. But you just got to make sure your technology policy covers that, so that they can't say, well, I have a lot of confidential stuff in there that is personal. You can say, well, we made you sign a technology policy. We told you the phone was going to be used just for country club business, and you take the phone and you can examine it and see what's on there. Like pictures. I can't tell you how many times we found naked pictures of people that they decide is a great idea to send to staff, or vice versa. It happens more often than you'd want to discuss. You also need to know about prior discipline, and I always like to find out what an evaluation looks like. And I also want to know whether they've had complaints of a similar nature, what the outcome was, because you can consider that at the end when if they deny it or they say I wasn't on notice that showing those kinds of pictures was inappropriate when they were written up 5 times for the same thing. So very important to check about prior discipline. And also prior complaints. Some people are chronic complainers and they're always filing complaints. Sometimes people think their job's in jeopardy, and that's when they decide to make a complaint. But you want to look at complaints for both parties, not just the person bringing the complaint, the person who the complaint's against. It's very, very important to do that. So again, can you examine a cell phone? Again, if you've given the cell phone to staff, yes, you can, certainly with a GM. F&B, sometimes, again, clubs will do that. You can examine emails and computers as long as you have a policy in place that allows you to do that. Certainly if you're doing an accident case where someone's claiming an injury and you're doing that in conjunction with a workers' comp case, it's very appropriate to go on social media and find out what is being said or being posted. It's not unusual to find pictures of an employee out water skiing when they've claimed they have a bad back and they can no longer work. And people like me know how to access all that stuff, and we do it on a regular basis. But it's one of the due diligence things that you should think of, depending on the type of complaint that you're getting. Also with social media, people will expose their biases, and you'll see what they may put misogynistic stuff on their website, hate-filled stuff, racist material. It is shocking what people will post, thinking that it's a great thing to do, and then they're subject to a racism complaint. They deny it, but you've got all this racist hate material on social media. So it's very important to look at that. It doesn't take long to do. It's something you can do very quickly. And metadata that's the data, if you've never heard the term, that is, if you take a picture on your iPhone, there's data that is automatically kind of time-stamped on that image, which tells you the geo-positioning of the picture, the date, the time, the device that it was taken on, and that's stored on the computer. So if someone wants to send you something, there's a way for you to look and find out exactly when the document was created. I had a case one time where somebody made a complaint and they said they weren't put up to it. This was their complaint. and nobody told them what to say or do. We completely suspected that this was part of a scam to try and force the club to do something they did not want to do. We looked at the metadata behind the document because the person sent it as a Word document. The last person to edit the document before it was sent as a complaint was the person we all suspected was behind it. So not only were they trying to pull a fast one, they also weren't very bright, because we then immediately knew that the complainant really wasn't the complainant. He was being put up to it by this other person. So that's another reason, if you get pictures or images, you want to find out how to access the metadata to see where it's coming from and the date. Where they'll say this picture was taken last week and it shows me being harassed, and you find out it was 8 months old or 2 years old and had nothing to do with reality, or it was taken somewhere else. So the interview process, and again, this may sound daunting to you, but it's not, in the sense that you just have to follow the steps. So again, prejudging, I say it over and over again. You may find a witness or a complainant that's got prior problems in the workplace. You just really have to try and set that aside and do the investigation as a standalone item. Just try not to be biased. Anytime a complainant comes in and they say something horrific happened to them, the worst thing you can do is identify with them and say, I'm very sorry that happened to you, because now you're acknowledging that it happened and you're expressing a bias instantly. You don't need to say anything. You don't apologize on behalf of the club. Don't do anything like that. Just let it be. You can say, gosh, it's really unfortunate series of events, the way you've described it, but don't get into identifying with them, because they're going to take it as an admission of guilt by the club, and it's not a good place to be. And when I do interviews, I'm very conversational. I don't interrogate people. I let people do the talking. In this business, as HR people know, I let people kind of talk themselves out, and then I get to my questions when I'm going to get to them. They're compelled to be there, and you just have to be very, very patient. We touched on confidentiality and being anonymous. Again, people can be anonymous to a certain degree, but you have to make sure that it's, and hold on, I just lost a slide here. My mistake, excuse me. I'm sorry, it looks like I lost my place. In terms of how I document my investigations, I tape record almost everything that I do. That can be a little uncomfortable for people who've never done it before. I would say that if you are uncomfortable doing it, don't, but it's my practice to pull out a recorder. I let them see it when they come in, and I always tell people it's the best way to have a record of what I say and what you say. Later on, I have them transcribed. If you're doing an internal investigation yourself, that can be expensive unless you have somebody else do it in-house. But for me, it's a way to maintain eye contact. It's a way to be less distracted. It's the most accurate record. It protects you, and it protects the person being interviewed, because you don't want to have somebody accuse you of something ever. I mean, it's not a good place to be. So always consider tape recording people. The more comfortable you are doing it, really the easier it's going to be. And all you have to do is identify yourself, the person, and get their consent to be recorded, and then off you go. If you don't get consent, it's against the law in California. Maybe not in other states, but it certainly is in California. So you always want to get someone's consent. And again, it sounds kind of daunting, but the more you do it, the more comfortable you get. It's almost like second nature. You bring somebody in, hey, Billy, blah, 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 and by the way, we're going to record this. If they want a copy of it, I always give it to them. It's their statement. And that's one way to overcome an objection. If you really want to get somebody on the record, you say, well, look, I'll give you a copy of it. I don't have a problem with that. But you won't be giving them copies of anybody else's interviews. So again, how to get the best information, again, staying in the middle, as I keep reiterating, always be respectful. I rarely ever accuse somebody. I let them talk and let them tell me their story. I do not confront people. It's not really a good practice of mine. You just let them say what they're going to say and remind them that this is their statement. It's not mine. And people will try to throw things in your way to stop you from getting to the truth. Your job is to be as patient as you can, again, and try to overcome those objections. It's very much like being in sales, where you're trying to get someone to give you the order, and but they'll always have 20 objections to do it, and your job is to say, well, no, here's a reason why, it's a good idea to do this. Again, patience is the key. Again, don't identify with the interviewer. Don't ever say, oh yeah, that happened to me too. That's just a bad practice. Even if you think it's something that's important to say, don't, because you're now exposing something personal that happened to you, which also represents a bias, which you don't want to do. You want to maintain independence at all times. I think we've again talked about this. So process and report. Again, my reports, and this can be as simple as you want to make it. I outline what the scope of work is, which is on such and such a date, a complaint came in, and here's what I was hired to do. I have an executive summary which simply outlines what I did. I talked to X number of people. I looked at X pieces of evidence, and you want to outline for the reader the steps you took to ensure you did a complete and fair investigation. I then give a brief summary of what the witnesses had to say, a timeline of the events, so anybody who looks at it is going to know exactly how things went, and an analysis of the evidence. And that's, again, the hardest part of the job. You have to now start sorting out fact from fiction and describing why you are reaching the conclusions that you reached. And that's where you're telling the story. You also have to do an assessment of credibility of each witness. And to do that, you have to assess their ability to recall, again, their bias, their motive, and all the various things that would impact somebody telling the truth or lying. And again, that's something that there's essentially 5 criteria on assessing the credibility of a witness. And you have to do it for each one of these cases. And it may sound silly at the beginning, say that's just too much work, but always think of the end. If someone gets fired, someone files a lawsuit, they go to administrative hearing, that assessment has to be there. The final stage are the findings. And again, this is the most important part of the report, because this is what gets everything running. Findings are going to be very specific to each individual and to the case itself, and then we'll talk about that now. So when you're doing these investigations, again, looking at the end of the road, when you go to court or a hearing, administrative law judges, civil cases, the standard is always a preponderance of evidence. That's the standard that's used in all civil cases. And that's the standard in workplace investigations that you have to use when you're conducting any workplace investigation. And what that means, essentially, is it more likely than not that the allegation occurred as it's alleged. It's a low standard. It's not a reasonable doubt. That's a criminal standard, which is very, very high. And here, this one is very, very low. There's 2 actually below that, a reasonable suspicion and another one. So when you're considering it, you just have to, does it just tip the scales ever so slightly in one way or another? And that's how you weigh the evidence. You also want to consider the procedures and the policies of your club when you apply it to the evidence. In other words, you have a definition of sexual harassment, and a lot of people will say, well, it has to be ongoing and pervasive to be sexual harassment. And in many cases, that's true. If someone comes in and makes a stupid joke, what are you going to do? Is that considered sexual harassment? It could be. In some cases, it might not be. If someone is constantly doing it, it's ongoing, it's pervasive, and making the environment uncomfortable, yeah, that's going to be sexual harassment, if that's the finding. So you always want to look at the policies and procedures, again, in the union contract to make sure that your findings are consistent with the language that your club uses, because everybody uses a different set of procedures or policies. Another very important thing to do is, I'm not a lawyer, so I do not make legal conclusions. I don't say in any report, Billy was sexually harassed, or Billy, there was a hostile work environment. So the way you get around that when you're writing these reports is that you say that the evidence that you gathered was consistent with the policy of the company as defined in the sexual harassment policy. So I'm not saying it was, I'm just saying it's consistent with the definition of sexual harassment, which is again in your policy, or the definition of whatever it may be. And that way you're not giving a legal conclusion. You're saying the exact same thing. You're just not saying they were sexually harassed. And the lawyers can do that. I'm not a lawyer, and I can't do that, and neither can you. You can't write a report and say, I did investigation and I concluded that there was sexual harassment. You can say it was consistent with sexual harassment as defined in our policies and procedures, or the laws of the state of California, that whatever you were using as your baseline for the misconduct and kind of the definition, that's what you have to say it's consistent with, or it's inconsistent with that. In other words, I concluded it was inconsistent with the policy regarding sexual harassment, and that covers you, that protects you as a non-lawyer. You can just stick to the facts. Lawyers will be lawyers. Hopefully none of them are on this call. So how not to write a finding. So allegation 1, Johnny sexually harassed Betty when he made sexual comments. Finding, Johnny sexually harassed Betty. So that is exactly what you do not want to say, because it's a legal conclusion. It doesn't give you any information. If you were to have to defend this somewhere, you would not be able to defend it. You may think it's expedient, but what this does is open up a can of worms. So when I write a finding, this is what a finding and allegation would look like. Did Johnny make sexualized comments to Betty, including remarks about her body and her clothing? And I would say the allegation was sustained. And I would say there was credible evidence that Johnny referred to Betty as XYZ. So that first sentence, or the second sentence, there was credible evidence. I don't say that there was evidence, because you're going to get evidence from different people. As an example, the respondent's going to say, I didn't do it. Well, that's evidence. And you're going to get the other person saying, I did do it, and then everything in between from all the other statements. And so when you assess the evidence, you are going to determine whether the denial was credible or not. And if you've concluded that just wasn't credible, there was this piece of evidence, that piece of evidence, they lied about something. And so you always want to include, when you write a finding, that there was credible evidence, because someone's going to say, well, what about the denial? That's evidence. And you can say, well, it wasn't credible. And then you give a description of what it was. Coworker Susie corroborated the allegation. They were in close proximity. They overheard it. They discussed it. And so you can see how I've taken the allegation and described for the reader exactly why I concluded it was a credible allegation and why it was sustained. And nowhere in there is there a legal conclusion. I said it was more likely than not that Johnny made the inappropriate statements as alleged, and then I cite the policy or insert the language, and that is an airtight finding that protects you, protects the club from exposure. Again, if it gets challenged, but you've gone through this process, you're protecting yourself. So regarding discipline, Again, that's not part of the investigation. It's only a fact-finding process. Again, do you know the past practices of the company? Make sure you follow those. If you get in a position where you are going to be making a recommendation, because that's part of your job, always make sure you know what happened before. So if your practice is anytime somebody violated policy A, we gave them 3 days off. So it's not going to be appropriate to give somebody 10 days off if you've always given somebody 3 days off. So, because then someone might again come back and say, well, you're biased against this person. You've always given 3 days, now you're giving 10. That's totally inappropriate. So make sure you're not stepping in it by knowing what happened before. What do you typically do? And again, if you're getting pressure from above to do something more, you need to find out why. And sometimes the conduct can be so egregious that it needs more time, but you want to make sure you sort that out in advance so that you're not being accused of a bias. And again, if requested, I will typically say I recommend that you take appropriate disciplinary action up to and including termination. That's my recommendation. And that then gives the general manager, the board, or the decider the range of disciplines that they can impose on somebody. All I'm saying is, yes, this warrants some kind of discipline, and then the range is from 0 to 100 miles an hour. And so that's kind of my practice. Might be my way of chickening out, but that's kind of how I do it. So suppose you're doing an investigation, then you find out about something else that happened that has nothing to do with your scope of work. What do? I don't include it in my report, and you shouldn't either. It's outside the scope of your work. You can go back to whomever or start a new investigation, do whatever you're going to do, but do not include it in your report. You can do what we call a side letter, which is if you were to hire me and I found out that during a sexual harassment investigation there was some thieving going on or some other misconduct unrelated to my scope of work, I would write a letter to the attorney or whomever saying, during the investigation I uncovered A, B, C, and D, and I want to make sure that you're aware of that. You're an agent for your club. I'm an agent for your club. So as soon as the words come out of somebody's mouth about other misconduct, the club theoretically is on notice about the misconduct. So you just can't ignore it. You can't say, oh, I didn't hear that. You did hear it. And again, that's another reason why you want to have an attorney involved to some extent, because that letter, if it's written to the attorney, it's under the umbrella of the privilege, and it's something that the attorney can then take up with the board. They'll say, well, Mr. Reynolds, by the way, found out that we're losing $100,000 a month because of XYZ. So again, keep it out of the report, but you really have a duty to advise the club in some form or fashion. You just cannot ignore it. And we are at the end of my presentation. I wanted to make sure, see if there's any questions at this point. We have a few minutes to go. I'm not sure the process, but if there are questions, I think you can ask them by writing in the chat section. And if not, then I appreciate the time to discuss this with you. As you can see, it sounds daunting, but if you just stick to the very basics, I think you'll be able to get it and do a really good workplace investigation.
Chris, thank you very much. That was a very clear and concise presentation, very detailed and I think understandable. We do have just one question at the moment. Can you speak to how you would handle the conversation with the complainant whom is not happy with the outcome and threatens to quit if action X is not taken?
Well, at that level, usually I'm not the person having that conversation. Sometimes I am, and that's where you have to explain from the very beginning that when you first talk to the complainant, you say, we're going to go through this process, and here's the standard that we use, here's how it goes, and you just have to explain the steps that were undertaken. If someone's going to do that, which they will, there's not much you can do except try to assure them that it was done in a fair and unbiased manner. And again, that's kind of, in a lot of ways, that's why you don't want to be doing them yourself, because then you're now in that position you just don't want to be, where you've done the investigation, now you're having to justify what you've done, as opposed to saying, look, we hired a third-party person, they're trained to do it, and this is what they came up with. Sometimes I tell people that an investigation you're trying to get to the truth, but the truth can only, it's limited based on what somebody tells you. So if somebody decides not to support the complainant as the complainant expected, which happens all the time, you've got to just accept that. So you just have to explain the process that was undertaken to ensure that it was fair. We talked to all the witnesses. I can't share with you what they said, but we weren't able to reach that threshold where we were comfortable making a finding that in fact it occurred based on the standard that we have to use. It just can't, and that's all you can do. It's frustrating when you have to have those conversations, and that's what I've done and what I would suggest you do. I'm not sure that answers it, but I hope it does.
Thank you. Are you able to scroll back to the certification slide one more time?
I am trying to figure out if I can do that. Hold on. I went through a couple of slides there that I didn't want to go through so fast. And
well,
so
it's not a problem. So
I
anyone
think I can. Hold on. Here, let me see. Now the whole thing just went away. That's not good.
Okay, well, we will send that certification information to those of you that attended. And so you will have that in the follow-up email, which will have a recording of the webinar as well as
Okay, so here we go. I did get to it. So let me just get to that. Sorry about that.
no worries.
Is this the page you wanted?
Yep, excellent. Thank you. I just want to make sure people can see those activity numbers, activity ID.
Sure. And if anybody there has a question about something like this, just shoot me an email. I'll be happy to answer it for you. Again, it sounds daunting and complex. It can be pretty straightforward. Or if you get stuck somewhere, like, what do I do? How do I say this? Make a finding. I'm happy to give you some language or guidance if you need it, so that you're saying it in an appropriate way. So, and that's about it, I think.
Well, thank you very much, Chris, for joining us today, and Mike as well. And thank you, everyone at your clubs, for joining us.
Okay, thank you.
Have a great day, everybody.